Hi, this is Katie Dwight here. Thank you for joining us again for this webinar, the fourth one and last one of the series of on-the-job training webinars. Sorry for starting a little bit late today. Again, we had some technical difficulties. Hopefully those have been sorted out. I'm here today with Becca von Beren, and we are going to be discussing some issues that are raised in the last quarter of the training manual. Becca will be talking about interviewing skills as well as the meaning of willful and persistent misconduct, and also how to order National Guard and Reserves records. And I will be discussing the prior honorable terms of service and writing statements. Much of the last quarter of the training manual is advocacy skills, and so today we're going to be touching on some of those. So I'm going to turn the webinar over to Becca now.
The broadcast is now starting. All attendees are in listen-only mode.
Hi, I'm Becca, and we're going to cover some interviewing skills first. So let's get started with some tips for starting the interview. So one important thing to do is create a safe environment for the veteran that you're going to be speaking with. And one thing that's important is, if as much as you can, if you have control over the furniture and the physical layout of the space that you're working in, try to be conscious of things like whether or not the veteran has easy access to an exit, or not having the veteran have sort of their back into the center of the room, you know, facing a wall, because a lot of times if a veteran does have post-traumatic stress, it can be a trigger to be in a crowded space and not have a clear view of the exit, or not be able to see the room and have their back to the center of the room. Another thing is being aware of your body language. You know, don't take and this is something that just makes anybody comfortable when they're first starting out an interview process. You know, don't be taking an aggressive stance that's, you know, leaning forward and, you know, really leaning into your desk. Sit back, have open body language, and always make sure to stress the confidentiality that exists when you're speaking to a person for the first time. And you also want to start with an open introduction. Ask the person how they're doing today. What brings you in? How can I help you? Let them direct the conversation first rather than making an assumption. You know, are you here for service-connected disability benefits because you notice that they're in a chair or using a wheelchair? You know, don't make assumptions. Open-ended questions. What brings you in here today? Some things to consider that folks don't always think about. The term veteran can be a difficult term for some people. Try asking, did you serve in the military, rather than, are you a veteran? And the reason that this can be important is because the word veteran, the VA uses the term veteran to refer only to those people who served in the military and are eligible for VA services. And since the regulatory definition of those eligible for VA services excludes many people who served in the military, you know, who may have gotten a less than fully honorable discharge, didn't serve for the required length of time, this term can be confusing to folks and also deeply insulting to those who aren't recognized by the VA as a veteran. So be conscious of using that term. Let the veteran self-identify. When interviewing someone for a discharge upgrade, ask the person, can you tell me about the events leading to your discharge, rather than asking, why did you get an other than honorable discharge? It's small things, but there's a sense of judgment in that. Why did you get a bad discharge, rather than, let's talk about the events that led to your discharge. These are very sensitive things for someone to discuss, so being mindful of your language can be really important to ensure that you're starting the interview out right and making someone feel comfortable and welcome to share their experience with you. So along that vein, avoid statements and questions that involve assumptions and judgments. Things like, what do or did you think of the war? Did you want to go to war? How do you feel about your service? What you did took a lot of courage. Now, you may think something like that would be a nice response to something that somebody just told you, but you don't necessarily know that they feel proud or courageous about what they did in service. They may feel a lot of shame, a lot of guilt, survivor's guilt. You have no idea. So to say what you did took a lot of courage, you don't know how they may respond to that or how they do feel about what they did. So be careful about making assumptions as to what would feel comforting or encouraging to somebody as they're telling you about their experience. Avoid statements like, I don't think I could have done what you did. And another comment that I've heard from a lot of veterans that is hard to hear is, thank you for your service. Because what I've heard from veterans is that a lot of folks feel very conflicted about their service, what they did in service. I had somebody tell me once, thank you for what? Thank you for all the awful things that I had to do, or, so be mindful that you really don't know what somebody feels about their service, and to make some of these statements is making assumptions. So be mindful of your language. Other things to think about, the main goal is seeking clarity. And when you're seeking clarity, that's going to be at the expense of comfort at some time. So you have to accept that these types of interviews are difficult. And while we want to make a comfortable experience for the veteran, when we're seeking clarity, we can't always do that. When we are seeking clarity, we want to take notes. We want to pause to summarize, to check that we have the facts and order correct. We're going to need to pause for clarifying questions when we need to. And those things can disrupt the flow of the conversation. They can sidetrack the veteran. But they're going to be necessary because we need to make sure that we have everything accurate. And I think the best way to deal with that is to discuss ahead of time. One of my goals here is to make sure that I have complete accuracy when I'm recording your experience. And some of the tools I'm going to use are note-taking, pausing to summarize what you say, and asking clarifying questions. And I apologize ahead of time that this may disrupt the flow of the conversation, but these are some tools that I'm going to use. And that way the veteran will expect that that's something you're going to do. When you're talking about traumatic events with a veteran or with anybody, it's important to ask open-ended questions rather than really picking at detailed asking closed questions about details. When you're starting out, you might have to do that later, but when you're starting out, to sort of move things along, ask questions like, do you feel comfortable going into more detail? Can you tell me more about the incident? Then what happened? And my go-to is, can you describe what happened next? Or how does that affect you now? And then you have to be comfortable with what may follow your open-ended questions. When talking about traumatic events, people often require more time to complete their thoughts. They may have difficulty maintaining a chronological order. And a tip for reorienting somebody is just be direct about it. You know, don't try to just sort of keep pulling them back. Just be direct. I want to make sure I don't miss any details. A moment ago you mentioned X, Y, and Z. Can you describe to me what happened after that? There will be pauses due to any number of factors. The veteran may need to reorient themselves. They may be experiencing a lot of emotions. They may be numbing. And it's okay for there to be silences. Don't rush the veteran through their recounting of their experience. There is a difference between reorienting somebody and rushing them. And that's something that you'll feel out as you do more interviews. And another big thing is educate yourself about PTSD and the symptoms that accompany PTSD so that you don't misinterpret behaviors that the veteran may display. They may avoid eye contact. They may feel emotionally numb. They may be irritable or agitated. They may not remember important aspects of the trauma. Don't misinterpret that as them not being telling the truth. They may avoid thoughts or feelings that evoke memories of the trauma. So educate yourself so that when these things come up, you know, if somebody gets irritated, you don't take it personally. You can stay calm and grounded in the interview. And always make sure you have relevant contact information on hand in case the veteran seems to be in crisis or need mental health assistance. And then some info and tips for interviewing people who have had a traumatic brain injury. Some people who have had a traumatic brain injury may have trouble concentrating or organizing their thoughts. They may have difficulty regulating their moods and or the tone and volume of their voice. Again, that's not something you should take personally. The more you know about these conditions, the more comfortable you'll be in the interview, which creates a better environment for both you and the veteran. If you're in a public area or if your office space is naturally loud, if you can, consider moving to a quieter location because noise distractions can be very difficult for some folks who have a TBI. Oftentimes, short-term memory deficits accompany traumatic brain injuries, and it's always a good idea to offer to provide the veteran with a written summary of what was discussed and a to-do list of any next steps. People who have a traumatic brain injury may have an especially difficult time remembering appointments. Don't place judgments on that. Ask if they would like reminders prior to appointments. Traumatic brain injuries can affect a person's cognitive skills. Offer assistance completing forms or explaining written instructions. And also an important thing is provide some extra time for decision making. And check in with the veteran periodically to make sure that you're having two-way understanding of what's being discussed and what's being decided upon. And take time for your own understanding. Traumatic brain injury can cause difficulties with speech, difficulty with finding words or choosing the right word. There can be long pauses in speech. Don't interrupt or try to finish sentences because that can create misunderstandings. So really give the veteran the time they needed to communicate fully so that you have a good understanding of what the veteran's situation is or decision is. And most importantly, ask the veteran what their specific needs are. Traumatic brain injuries affect people in many ways, and it's best not to make assumptions. Tell the veteran you understand that they have a traumatic brain injury, and see if they have any requests that might assist them in your work together. And you can say, you know, for example, I've done X, Y, and Z with other folks. Do any of those things sound helpful for you? This is a very quick section, just a quick tip about obtaining National Guard and Reserves records. In addition to what's on the SF-180 request, so on page 3 of the form, which indicates where to send your requests, it's very important you also need to send your request to the state adjutant general in the state in which the veteran served, and you'll have to look that up. My go-to is to look it up on Google to find the contact information for the state adjutant general, and don't just send a request to whatever the address is that you find online. Find a phone number and call and say, I need to request records. What's the proper process? Because many times I've sent the request in via the SF-180 to the place indicated on page 3 and either haven't received any records or received very limited records, and it isn't until I go to the state adjutant general, actually speak to somebody, find out where to send the request, send it in, and then I'll get complete records back. So just a little tip on that. And then here's a pretty difficult section, or a pretty convoluted section. So in the context of character of discharge determinations, we're going to talk about the meaning of willful and persistent misconduct. So in the regulation, just to orient ourselves, we're talking about character of discharge determination. So here's the regulation. So the VA has the capacity to grant a character of service determination to allow a person with an other than honorable discharge or a bad conduct discharge granted by a special court martial. The VA can allow them to have VA benefits if they determine that their discharge was under conditions other than dishonorable. However, Section B reads, a discharge or release from service under one of the conditions specified in this section is a bar to the payment of benefits. And it lists bars, and then after that, Section D actually defines some things that will be considered to have absolutely been issued under dishonorable conditions. So a discharge or release because of one of the offenses specified in this paragraph is considered to have been issued under dishonorable conditions. And one of those is willful and persistent misconduct. So if the VA adjudicator determines that the veteran with an OTH or a BCD committed willful and persistent misconduct, then their discharge will be defined as under dishonorable conditions, and they will not be eligible for a favorable character of service determination. So what does willful and persistent misconduct mean? if you read further in the regulation, it says, this includes a discharge under other than honorable conditions if it is determined that it was issued because of willful and persistent misconduct. A discharge because of a minor offense will not, however, be considered willful and persistent misconduct if service was otherwise honest, faithful, and meritorious. So that's what we just read. So what is the standard for willful and persistent misconduct? According to CAVET, it is a murky statutory and regulatory framework. So that's very helpful. That gives us a little idea of what we're walking into. And advocates have observed that willful and persistent misconduct is the most common basis for denying a COS application. So it's definitely something to look out for. I know that we've observed in this office that a lot of willful and persistent misconduct is definitely a commonly used section of the regulation to deny COS applications. And additionally, defining the standard has generated the greatest amount of appellate review for that section of the regulation. So let's think of some ways that we can go about defining it, because there isn't anything directly on point that provides a nice and neat definition, so we kind of have to cobble some things together. So there is, in 38 CFR Section 3, in the definition section, there is a definition of willful, or of willful misconduct. However, while this offers possible guidance, Part 3 governs VA benefits adjudication generally, and in the context, willful misconduct is used for a different purpose. It's used, so if you're seeking compensation and pension for an injury, but the injury was found to have been the result of willful misconduct, you're not eligible for compensation. It won't be considered to have been service incurred. So it's not on point, but we can look at it to see what they mean by willful misconduct. We can look at it for guidance, but we can't really rely on it for when we're looking at character of discharge determinations. So it means an act involving conscious wrongdoing or a known prohibited action. And if you go on in the regulation, you'll see that it's not pertaining to character of service determinations. It involves deliberate or intentional wrongdoing with knowledge of or wanton and reckless disregard of its probable consequences. A mere technical violation of police regulations or ordinances will not per se constitute willful misconduct. And 3 is entirely not relevant for COS determinations. But what can we take away from this? Well, we can say that in this context, it definitely requires general intent. It doesn't require specific intent, and just simple negligence would not be enough to constitute a willful misconduct. So that's something we can look at. Now we can't forget the word "and." So we have willful misconduct, and it also has to be persistent misconduct. So what can we look to for persistent? Now we know from decisions and case law that multiple acts of misconduct definitely satisfy the definition. But it's also been found in case law that an act of misconduct that lasts over an extended period of time can be persistent, which is sort of unexpected. So in one case, 32 days of AWOL met the criteria for persistent, even when that was the only act of misconduct in the veteran's record. It is interesting to note in this case the veteran's total length of service was only 176 days, so that's 32 days is quite a big percentage of that total service, but still it was the only act of misconduct. And at least one veterans law judge has taken the view that each day that a service member is absent on AWOL constitutes its own offense. So each day is an act of misconduct, which is how it constitutes persistent misconduct. So that's an interpretation. Now, misconduct. What constitutes misconduct? Now, it's definitely not the same as offense as used in 38 CFR 3.12D3, which addresses offenses involving moral turpitude. So that's one of the bars for a character of service determination, but we shouldn't confuse the two. Misconduct is different than an offense involving moral turpitude. Those are certainly more serious. We know that offenses of moral turpitude are also felonies or misdemeanors, whereas misconduct can involve behavior that is just improper, like having an unauthorized absence or things like that. So let's try and define it by what it is not, which is looks at the later part of the regulation. So the later part says a discharge because of a minor offense will not, however, be considered willful and persistent misconduct if service was otherwise honest, faithful, and meritorious. So this little sentence tells us what willful and persistent misconduct is not. And defining minor has come up a lot in the context of absences and determining whether an absence was a minor act of misconduct or a serious act of misconduct. So that's where a lot of the case law addresses the term minor. And in the 1990s, several VA cases seem to agree that an offense which interferes with the performance of military duties cannot be a minor offense. Not a bright line definition there either. However, there's still a lot of questions over the definition of minor for the purposes of this section. One thing that the court does seem to be consistent on is that a period of AWOL that lasts for 30 days or more is not minor by virtue of the Manual for Courts Martial. The Manual for Courts Martial. So that seems to be one thing that is consistent. And what about the term honest, faithful, and meritorious service? There's no VA regulation on point. And the case law seems to focus on the word meritorious rather than honest and faithful, and defines it to mean that the veteran performed above expectations and in a manner worthy of praise, reward, or esteem. And it's really a high standard. If you look at some of the cases, there is a case, the citation is right there, where one letter from the commander saying that the service member's discharge would improve morale and discipline within the unit was enough to show that the service member's service was not meritorious because the court said that his continued service would have been a detriment to the military. So that was just one letter in the veteran's whole service record. So, what guidance do we have from regional offices on the definition of willful and persistent? I don't know. In terms of what we've seen just here in our office, it's really all over the board, and even in taking cases, both decisions within one regional office and cases from different regional offices, it varies a great deal. What arguments seem to be strong, sort of when willful and persistent misconduct gets used, how it's defined. There doesn't seem to be any consistency in the definition of willful and persistent misconduct coming out of the regional offices, as far as we've been able to tell. So we can also look to military law for potential guidance. So for willfulness, from the military judge's bench book for the Army, it means intentionally or on purpose. And in cases including willful disobedience of an order, the disobedience is willful when there is an intentional defiance of authority. So here we see again that simple negligence, even gross negligence, would not constitute willful. So general intent is necessary, specific intent not necessary, but negligence is not enough. So guidance from the UCMJ, if we look at several of the articles, we see willful being used to mean reckless and wantonness, gross negligence with deliberate disregard for the foreseeable results to others, a negligent act or failure to act with a gross or deliberate disregard for the foreseeable results to others, or willfulness being a sort of aggravating add-on to wantonness. And again here, this is different than we saw in the military judge's bench book, in the sense that gross negligence is sufficient under a number of the UCMJ articles. Now what about minor? We can get some guidance from military law there. It's generally defined by military courts and the Supreme Court as misconduct not involving moral turpitude or any greater degree of criminality than is involved in the average offense by a summary court-martial, and that comes from the Manual for Courts-Martial. And the 1951 Manual for Courts-Martial actually directed commanders and courts to evaluate the nature of the offense, the time of and place of its commission, and the person committing it to determine whether it was minor or serious. So that seems like a much more in-depth kind of holistic approach to whether or not it was minor, rather than is it a offense punishable by summary court-martial, or is it a crime of moral turpitude. The Manual for Courts-Martial gives example of serious misconduct being escape from confinement, willful disobedience of a non-commissioned petty officer, and protracted AWOL. Case law, the court has equated civilian felonies and serious military convictions by court-martial for an offense which confinement in excess of 1 year or a dishonorable discharge was imposable as those would constitute serious offenses, and again gave examples of prolonged periods of AWOL and desertion as serious misconduct. So thank you for suffering through that really convoluted attempt to define willful and persistent misconduct for character of service determinations. I think the takeaway point is there's a lot of room for creative advocacy, both on the part, on the part of the person representing the veteran. There's a lot of places you can pull from, especially if you have, if the incidents of misconduct are absences. The case law is all over the place, and you can really pull from a lot of different sources to rebut a finding by a regional office that the applicant is barred from a favorable character of service determination because they committed willful and persistent misconduct. Instead of seeing it as a bad thing, that there really isn't a definition out there to be found. We can sort of take that to our advantage to come up with creative arguments, work what's in our favor, and try not to let the regional offices get away with using willful and persistent misconduct as sort of the go-to, just, you know, rubber stamp denial. So there's a lot to work with there. And now I'm going to turn it back over to Katie for her to present on her topics.
Hi, this is Katie Dwight, and I'm going to be talking about prior terms of honorable service. And that is important where a service member has gotten a discharge that was considered dishonorable for VA purposes. If they have a prior term of service that was honorable, then that term may provide the veteran eligibility for benefits. An honorable prior term of service will be the basis for eligibility for health care, housing benefits, educational benefits, etc. It cannot form the basis for service compensation if the disability was incurred during a period of time considered dishonorable. Then another term of service will not help that person get service-connected compensation. To qualify for benefits from a prior period of service, the service member must earn veteran status. So that means they must have had active service, have a discharge, and the discharge must have been under conditions other than dishonorable. So that's fine when you have two terms of separate terms of service. That makes sense. If you have someone who's served, say, signed up for 2 years of service, served 2 years, then takes a break, re-enlists, serves 2 years, then you clearly have two terms of service, And if the second one was dishonorable, the first one was honorable, then that person will have benefits. But in many cases of reenlistment, the person does not serve a full term of service before reenlisting. So in that case, in 1977, Congress passed a law allowing for benefits for a prior term of service where there was no actual discharge because the service member enlisted or reenlisted. And that type of discharge, the VA calls it a conditional discharge. So that's where there's a reenlistment prior to completion of commitment. There's not really a discharge, it's a legal fiction. If an enlisted person has satisfactorily completed one contracted period of enlistment while serving on a subsequent contracted period of service, under a new enlistment, the VA will declare that the enlisted member was conditionally discharged for the purposes of creating a period of service for VA benefits purposes. And then they also refer to the date of the end of the first term as being the release from active duty date. That's how the VA refers to it. And then you also have the constructive unconditional discharge, which is the date of reenlistment. So say you have someone who enlisted for 3 years. After 2 years, they reenlist for 4 years. The conditional discharge will be after 3 years, but they reenlisted after 2 years, so that's when their constructive unconditional discharge is. Their release date is the date of the conditional discharge, after 3 years. So to have a prior term of service, there are these 3 requirements. You must complete a period of obligated active duty service. You must have intervening enlistment or reenlistment and release under conditions other than dishonorable at completion of period of obligated service. So what the VA does is basically if you had a second or subsequent discharge that was dishonorable, the VA will go back and look at previous terms of service and determine independently whether those should be considered other than dishonorable. So they're basically doing a character of discharge determination for that period of time. And so they're going to be looking for willful and persistent misconduct. And they're going to be looking at the regulatory and statutory bars, such as going AWOL for 180 days or more, having a general court-martial. So just basically going through their normal steps for the character of discharge determination, and if they find that that previous term of service was honorable, a veteran will be entitled to benefits. This can be confusing you can't always tell this on the DD-214 that there's been a reenlistment. You're going to have to ask the veteran whether they ever reenlisted, because sometimes it's not on the DD-214 or it doesn't say what the character of service for the original term of service was. So you have to discuss it with the veteran. And also we found that there's some confusion at eligibility offices at VA medical centers and clinics, that if you show up with the DD-214 that seems to indicate a prior term of service, but there's no indication of what that what character of service was given for that prior term. The VA will just send those veterans away and oftentimes telling them they're ineligible when in fact they just need to apply to find out whether they would be considered, their prior term would be considered honorable. There's other types of extensions of service that could make it so that there really is no prior term of honorable service, even though they've served a long period of time. Regular Army commissioned officers often serve their entire careers on indefinite commitments without a single break in service. So if they are ultimately discharged after 18 years for misconduct and get an other than honorable discharge or a bad conduct discharge, they probably do not have any prior term of honorable service to depend on. Army non-commissioned officers also serve on indefinite reenlistment contracts. And again, that seems to be it's just one continuous period of service, so they would not have a prior term of honorable service to rely on. Enlistment extensions are different than reenlistments, where the term of an enlistment begins on the date of reenlistment. A term of an extension does not begin until completion of the first term of service. There's no definitive guidance for how to treat enlistment extensions. The BVA in at least one case has referred to an extension as having a different characterization of service than the initial enlistment, which suggests that a period of extension may be found to be a separate and distinct period of service, but the BVA's decisions are not binding. Then you have stop loss, where service members are their terms are extended. In that case, service members have probably satisfied the minimum active duty service requirement and already completed an entire contracted term of service. So something that occurs during the stop loss period that leads to a bad discharge, they probably could argue that they had a previous term of service that qualifies. Extensions for medical treatment. Service members sometimes are extended beyond their ETS dates for medical care or hospitalization, or to complete processing in the disability evaluation system. Such service members have already likely satisfied the minimum active duty service requirements and already completed an entire contracted term of service, so they should qualify for having a prior term of service. When you have 3 or more consecutive enlistments, that's when things get a little confusing. The first period of honorable service for VA purposes will be the initial enlistment. And intervening in reenlistment does not end the first period of service for VA purposes. According to the M21, the VA instructs examiners to run each term of obligation consecutively when determining periods of service for VA purposes. Each term of enlistment commitment is added one after the other. So here's an example where this person re-enlisted twice. Enlisted for the first time December 20th, 2000 for a 4-year commitment. Then re-enlisted before the 4 years were up, May 1st, 2004 for a 6-year commitment. Then re-enlisted before that 6-year term was up for another 6-year commitment. And what you have here then is if the misconduct was committed on June 1st, 2010, well, the first term of service would be considered 4 years because it was a 4-year commitment. So it would be considered from December 20th, 2000 to December 20th, 2004. The second 6-year commitment would be considered to be, and again this is sort of a legal fiction, would be considered from December 20th, 2004 to December 20th, 2010. And the next 6-year commitment would be from December 2010 to December 2016. So if the commitment, if the misconduct occurred on June 1st, 2010, that would have occurred during the second term of service, which means this person only has one honorable term of service. You might think that that person would have 2, but no, they only would be considered to have one prior term of honorable service. So I hope that makes sense. I'm going to move on now. Oh, just one last thing. If you commit any of these acts or related acts, you will not be eligible to use a prior term of honorable service for benefits, which you probably won't care about because you're going to be in prison for quite a long time. Okay, so now I'm going to move on to writing statements. In writing statements, it's an opportunity for the advocate to try to persuade the examiner, the VA rater, to decide in favor of your client. So you're trying to write persuasively, clearly, and this here is the beginning of a statement written in support of a claim for PTSD. So what you have here, it starts at Swords to Plowshares represents John Smith before the Department of Veterans Affairs. In support of his pending claim for service connection for PTSD, we have attached the following evidence. So right off the bat, he's stating that this is a claim for service connection for PTSD, and that's what this statement is going to be about. And then he's going to have attached these 4 letters, statements, to his statement in order, so making it very clear, making it easy as possible for the rater to refer to those. And then in the introduction, you want to make clear what it is you're applying for, and you want to state the rules for obtaining that benefit. So, for instance, here he's applying for service connection for PTSD, and he states the rules here. Service connection for PTSD requires 1, 2, and 3. So then in the next part of the statement, we move to a discussion. And the discussion is going to cover those rules. He's going to have evidence and discussion of 1, 2, and 3 in the discussion section. So he goes over the evidence that he's submitting. The letter first there's a letter from Dr. Johnson, and he diagnoses PTSD. So that proves one prong, that the veteran has a current diagnosis for PTSD. And then he provides the stressor statement. And he quotes from the statement about especially stressful or traumatic incidents. And that proves or goes towards proving that he did experience, Mr. Smith did experience a stressful or traumatic incident. Then the next pieces of evidence are a buddy statement, which goes to corroborate Mr. Smith's stressor statement toward authenticating that the traumatic incident did occur. And then finally you have a letter from Mr. Smith's mother, and the purpose of that letter is to, she cannot have anything to say about the stressor because she wasn't there, obviously. But what she can say is that she's noticed the symptoms. She's noticed the way that her son has changed. She was in a position to know her son before he went to war, and then to see him when he got back and see how he's changed. So she can provide that information. So that goes towards his diagnosis of PTSD and his symptoms of PTSD. Then you have a very simple conclusion, once again stating the rules that are required for meeting, for being granted service connection for PTSD. In the conclusion, you may want to just quickly summarize what you've stated in the discussion, or just state again what benefit you are seeking for your veteran client. And that's it. This is a very simple statement, and you know, writing is a lifetime learning to write well is a lifetime process, and not something that you can be taught. But if you keep it simple, I think you're just more likely to succeed in what you're doing in making the purpose of your statement very clear. Making it as simple and clear as possible is what you want to do. So I did not have a statement of facts in the last statement, but often a statement of facts is a good idea. In more complicated cases, this one is from a character of discharge determination. And again, I know that you all are in busy offices. Some of you are busier than others, so the kind of time you have to devote to writing statements could be very limited, but perhaps there are other ways that you could gain more time to focus on these meritorious cases by leaving out the frivolous cases. For instance, I've seen several applications from CVSOs for service connection for personality disorders. And that's never going to happen. You can't get service connection for a personality disorder. And so why spend the time on that when you could spend it working on something like this? So in this case, you simply, in the statement of facts, you start off by stating the branch of service, what the MOS was, where he served in basic training, any achievements that he had you want to put in the statement of facts, because you want to have the statement of facts put your veteran in a positive light as much as possible. You don't want to hide the misconduct that's occurred. You want to state that right out, but to the extent you can focus on the achievements that your veteran client had succeeded in, that's where you want to put your emphasis if possible. So we talk about the Certificate of Achievement for his participation in a tutor program, and he was an honor graduate from AIT. He went to Kuwait. And was part of, he's assigned to, you tell them what unit he was assigned to. Here we've stated that he used marijuana. There's no point in, trying to pretend that didn't happen. Then we talk about in a character of service determination letter, we're going to talk about war experiences because that can be mitigating evidence in favor of the veteran. And so we quoted from his stressor statement about some of the stressors that he was involved in. A statement from the sergeant showing that he demonstrated discipline, dedication, and bravery. You're putting in all the pertinent facts about what happened during service in your statement of facts, and like I said, to the extent possible, trying to put your veteran in a positive light. So that's the purpose of the statement of facts. This here is a stressor statement, and with a stressor statement, you want to help your veteran to craft a good stressor statement. You want to put in a lot of detail. You start out up front by stating which unit the veteran was in and when he or she was deployed. And in this one he explains, he was in an engineering company. Then he talks about his life, a little bit about his life before going into service. And this is good for setting kind of a baseline, because when we see what his symptoms are later, it's going to be in stark contrast to just the normal life that he had prior to service. Then he talks in general about what his role was in Iraq, building bridges, working 12 hours on, 12 hours off. And then gets to his first traumatic incident. And the stressor forms that the VA provides, I believe, wants you to put a specific date, and rarely, if ever, does a veteran remember a specific date for that something occurred. It's just not feasible. So we try to put as closely as possible a range of period of time within which the veteran believes it occurred. So I'm just going to read this. We were on a convoy to delaunch a bridge. We were traveling through Hilo when a suicide bombing went off. I was driving 5 or 6 vehicles back behind the vehicle, which fortunately was a heavy armored vehicle, so no one was hurt. But there was chaos and screaming, and it was difficult to see because it was very dusty. We were sitting ducks, so we had to keep moving. When I got to where the explosion happened, there was so much dust I couldn't see the vehicles ahead. Out of the corner of my eye, I saw a lady screaming and a body on the ground. I kept driving forward, but I couldn't see anything with all the dust. I just hoped I was driving in the right direction. There were crowds of people around, and I prayed that they were getting out of the way, but I couldn't see if they were or not. I just had to keep driving until we got to our destination. Later on, when we got to the bridge site, I realized that I had run over people because I found body parts in the wheel well of the vehicle I was driving. I felt horrified and worried that I had run over children. I could not stop thinking about it and dreaming about it. So I think the strengths of this statement are just how visceral the details are, describing the dust and the screaming and the noise, and you can really picture him. You picture the scene, and this is going to help to create a picture for the rater, to humanize your client for the rater, to create sympathy for the client, because when you learn that he may have run over people, it's just, it's a very, I feel emotional just reading that, and that's what you want. You want to stir the emotions of the reader. Then he talks about his life after service. I got out in the middle of the military in October of 2005. In December, I started drinking because I couldn't sleep, and drinking helped. I had dreams about running over people. My girlfriend at the time had me hospitalized because I was drinking so heavily that I had gastrointestinal bleeding. I had an alcohol-induced seizure in early 2006. And jumping to the next paragraph, I started having auditory hallucinations in March 2009, in which voices were telling me to commit suicide. Then the voice of air conditioning and heaters in my apartment started to sound like voices coming out of the vents. It sounded like my neighbors were planning to do harm to me. I was constantly afraid that people were coming to get me. I had such bad insomnia I slept at most 2 hours of sleep per night. So it goes on from there, but you're getting the idea. Again, it's very, there's a lot of detail, and it's very descriptive. And the contrast between what he's describing now and what he had written about his life prior to service is really amazingly different. Also, just technical things are that putting in the medications here near the bottom, and what those medications are for is a good idea. And then at the bottom, I declare under penalty of perjury of the laws of the United States that the foregoing is true and correct to the best of my knowledge and belief. That's some legalese there that basically means that when the veteran signs this, he's swearing, he or she is swearing to the truth of it. and the VA likes to see that. The wording doesn't have to be exactly like that, but something close to that. This is a statement from a friend, and this was a friend who knew the veteran for a long time, from being children. And the veteran he's talking about was a victim of military sexual trauma, although the writer doesn't know about it, but he still can write an important letter because he knew the veteran so well before and saw him and spent a lot of time with him after service. And again, there's some details that are important. He describes him crying because he couldn't remember a friend from childhood. Describes him as though he seemed like a zombie. So those kind of details are very descriptive. This one doesn't have it, but again, you would want to put the I declare under penalty of perjury little statement at the end. So that's just an introduction to writing, and there's a lot more to it, and it takes a lot of practice. But hopefully that just gives you a little bit of an idea. And you're going to be talking about this more at your Phase 2 part of the training. And speaking of Phase 2, I just wanted to tell you briefly about the format of the accreditation exam, since that's coming up soon. You've probably been told this already, but there's 10 questions that are closed book questions. And you should have been given a study guide at Phase 1 to take with you so that you could study during between Phase 1 and Phase 2. You'd have time to study and memorize. These questions pertain generally to eligibility, but any part of the any paragraphs or pages that are mentioned in the study guide are fair game for closed book questions. The questions are either yes, no, or multiple choice questions. And then you have 40 open book questions, 34 of which are multiple choice, 6 of which are fill in the blank. And those questions will be taken from the training manual, everything but California benefits, and the sections on advocacy at the end. And 35 correct answers is a pass. That's all I have now, and so we'd like to see if anybody has any questions.
Hi, Kate.
Yeah. Hi. I'm not sure if you can hear me, but the 40 questions will be from the training manual, which is the one that we created with the white binder. And it will cover all of Phase 1, and then any it will also cover, I can't remember if you covered discharge upgrades or curative service determinations, but those are fair game as well. just that the character of service and discharge upgrade sections, I'm not sure if you covered those in phase 1 or they're coming in phase 2, but those are fair game for the test, for the exam. Okay, I think that's all for now. Good luck in phase 2, and good luck on your accreditation exam. I hope some of this has been helpful. Yes, one last thing. Fair game means it could be covered on the examination. The examination, I know, has at least one question about discharge upgrades and at least one question on character of service determinations. Okay, so that's it for now. Thanks a lot and good luck. Take care. Bye-bye.